Welcome everybody to today's webinar. My name is Jane Stevens. I'm the training manager here at Zolo, and I am joined today by Michael Solomon, who is doing a 4-part series. Hopefully you guys have attended the first 2. They've been super informative. Today is part 3 of the 4-part series. So Michael, welcome. Thanks for joining me.
Hi, welcome. Thank you, Jane. I need to apologize first and foremost. I was a little bit late on jumping on. We're having some issues, not with technology, but I've just got something personal happening right now. So I may need to take some calls periodically from time to time. I'm going to try and make sure that that doesn't happen, but you know, such is life.
Yeah, do what you need to do. I've got Hamid here on the call as well. So yeah, if you need to jump off for whatever reason, him and I can facilitate. So yeah, welcome. Thanks for making time for us today.
Thank you. I'm so happy to be here again. Today we're going to be talking about notice of rent increases and that's all that sort of fun stuff. So actually what I'm going to do is I'm going to just do a quick screen share so then everybody can see that I'm pulling the information actually directly from our website today. So lots of great information to happen here today, talking about rental increases during this market and then increasing the rent after your tenant leaves and what that looks like. And in addition to that, you know, we'll talk about how some rental properties cannot be increased and so on and so forth. So just before we get started, I'm actually just going to shut my video off and put myself on mute because I need to close my door because we have lots of hustle and bustle going around here today. Actually, somebody's going to close it for me. Thank you. So I just want to make sure that everybody can hear us clear and concisely. So before we get started, we're going to leave a question and answer period for the end. And then if you guys have any questions, of course, I'm always here to field them and help you guys as well. So rental increases happen typically at the end of the anniversary period of the lease. So what we're talking about is if you've got a rental that your landlord has entered into, maybe they've entered into a 1-year agreement, and last session we talked about the standard lease agreement that is required by the government of Ontario. So when that standard lease expires and the tenant then goes month to month, that's typically when the rental increase comes into effect, normally on a 1-year period. However, I have seen rental agreements that are 2 to 3 years in length, which then, you know, poses an issue for the landlord because the landlord then has agreed to a rent that is subject to 2 to 3 years instead of actually being able to increase the rent. So what we're going to talk about today is the standard form N1, which is used to increase the rent. Now, for this past year, there hasn't been any rental increases that have been allowed due to COVID-19, but we are experiencing rental increase. I'm just going to talk about rental increase guideline for 2022. And the rental increase guideline for 2022, I don't know if anybody knows, is actually going to be 1.2%. So prior to COVID-19, it was 2.2%. And what we're seeing now is we're seeing actually below inflation, because what's been happening is we've had such a hot market that you know, the rental prices have steeply increased. But those that are in rental agreements now, the board is saying, you know, we recognize the fact that there was, you know, some undue hardship over the last couple of years. We haven't given a rent increase for the last year. So for the next year, we're going to give 1.2. So rental increase for 2022 starting January will be 1.2. However, if your lease runs, let's say, for example, from May to April, you cannot increase the rent in January. You can only increase the rent in May when the lease then becomes expired. Now, often questions come about with respect to rental increases, whereby the landlord says, well, I've done extensive renovations on my property and I need a rental increase above 1.2%. So now we're talking about something that is called an above guideline increase. Above guideline increases are completed when the landlord has done or experienced significant increase in costs to the property. So for example, these would be things like how I just had a landlord who put a roof on his property that cost him $500,000. Now, this property is not a small property, it's a very large property, and it's located, downtown Toronto. So of course, when we put on, a new roof that costs $500,000, we want to do an above guideline increase because we want to make sure that, the tenants are going to be able to pay for those substantial costs. And it's not just because the landlord wanted to replace the roof actually needed to be repaired in entirety. Okay, so that form that we would use would be an N2 form. And I don't know why this keeps happening. Let's just see. Oh, it's not even giving us the. So it looks like some of the links on our website are broken, so I'm going to have to bring that to their attention as well. So the notice of rent increase is the form N1. Now the N1 form, which I'm sure some of you are familiar with, will also state that the rent increase has either been approved by an order under the Residential Tenancies Act, because we're getting an above guideline increase, or the rent increase must be approved by the Residential Tenancies Act. And I've applied to the board. So these are separate applications when you're looking to do an above guideline increase. However, if your landlord is just doing a standard increase, they don't have to worry about this section below the or. So they just have to worry about filling this out, making sure the data is correct. And there is something called a fatal error. So if the address for the rental unit is not the same as the address that's on the lease, then you have to make sure that you're following that correctly. Otherwise, if you don't actually enter in the rental unit information properly with what it says on the lease, the board could actually say that this rent increase is null and void. Okay. Now, the rent increase must be given at least 90 days before the rent increase takes into effect, and that the landlord can only increase the rent if at the 12-month period that the lease is coming to an end. Okay. And that if they're in a fixed term, then it must become month to month. Okay. Now, there are other applications that can be done for rent increase: notice of rent increase, unit for partial exemption, and notice of rent increase for charges in a care services home, which involves meals. None of these two, N2 and N3, I don't think you're going to have to worry about. Now, what I find really interesting is now the Landlord and Tenant Board has said you can actually get an agreement to increase above the rent guideline between your tenant and your landlord. Okay, so you can say that the landlord and tenant will agree to a rent increase by a certain date, given the following capital expenditures that have occurred, but it can't be more than 3% plus the 1.2, so 4.2 in total. And then you have to be able to describe in detail exactly what the rent guideline above guideline rental increase was for. So what were the capital expenditures that happened? So these could be things like property taxes went up significantly. Maybe the home was revalued and reassessed by MPAC. And that happens quite frequently, where we see, for example, MPAC may peg a house at $400,000, but if the house were to appraise today and it appraises at 1.3 million, obviously the property taxes are going to change. So this could be the N10 form, which you may wish to have your tenants and landlords agree to. Again, when we talked about filling out forms, make sure that the landlord is the one that is actually signing for this, because we talked about this, I believe, in our first incident where we said due to a certain case called Shirelli, whereby the Shirelli was not a licensed representative with the LSO, that everything he did ended up being kicked out of court and he ended up with a fine, right? So we just want to make sure that the landlord is filling this out correctly, and that we're using the landlord's signature and the tenant's signature. In a roundabout way, this is pretty much how we go ahead and deal with above guideline increases and how we deal with standard increases. There have been a couple of cases where failure to provide proper notice and making any changes became unlawful, void, and unenforceable. And we've actually got those cases. So some light reading material, if you like, listed here on our website. And again, I'm just going to put our website in the chat box for you lovely folks in case you ever need to take a look at what it is that you may need assistance in looking at for your landlord clients. Okay, and you cannot retroactively claim a rent increase. So I can't go back if I never increased my rent in 2019, but I could have increased my rent. I cannot go back in time. So that's another condition of the Residential Tenancies Act, is I can't say, well, I didn't increase in 2019, but I'm entitled to a 2.2% increase. So I'm going to add on 2.2% plus another 1.2 today. So those types of clawing backs, and I call it the time machine method, doesn't necessarily work. So, and there are cases, again, listed on our website where it explains that, you know, going back in the time machine is not something that can be lawfully done, and that those charges become unlawful and they become null and void, which essentially means that, guess what? The tenant can apply to the board to say that the landlord has been unlawfully collecting rent or may unlawfully be withholding rent from the tenant. So all of those things become pertinent in making sure that, you know, we protect the rights of our landlords. Okay. If a landlord wishes to increase the rent by issuing a notice of rent increase, the landlord must be careful to use the proper form. Again, we've gone through and we've explained those proper forms, and that a minimum of a 90-day advance notice must be forthcoming to the rate change. Okay. Now, I know that we've only talked for maybe about 10 minutes, but this is how simple notice of rent increases are to deal with. So I'm actually going to open up the floor to some Q&A if anybody has anything that they'd like to address. Jane, I'll let you sort of handle that, so then, you know, we can field questions appropriately.
For sure. So you guys have a couple of options. If you want to just in the chat, let me know what your questions are. Although if you have a situation, it's probably better to unmute yourself so that you can explain the situation. Let us know what your question is, and Michael can help you with that. So I'll kick it off. I have a question for you, Michael. So
Sure.
If proper notice was not given, but an above guideline rent increase was agreed to between the landlord and the tenant, can that later be disputed by the tenant?
It could be. Yes, which is why we need to fill out the N10 form.
Okay. Okay. All right, and that's 90 days notice.
Correct. And on the N10 form, remember, detail is everything, right? So we can just say property taxes increased, right? But that's not enough detail. So there's a case called Metro Ball, where Metro Ball explains that an extreme amount of detail is required in order to substantiate the landlord's position. So saying property taxes increased is not enough information. What did the property taxes increase by? What were they last year in comparison to what they are this year? Why was the increase done? What happened? All of those things, right? So instead of saying property taxes increased, we may wish to look at on or about November 18th, 2021, MPAC reassessed the property. Property was previously valued at X. MPAC reassessed the property to value X. And now, given last year's property taxes, which were $3,500, MPAC has now determined that property taxes for this property should be $6,500. And the substantial increase now therefore warrants the above guideline increase. So we do have a question. So anytime the landlord invests on the, I'm just going to read this out. So anytime the landlord invests on his property, he can increase above the guidelines rent increase. Yes and no. So they must be reasonable, right? So if you're just putting in, I don't know, a couple new doorknobs and I don't know, you only spent $3,500, that's not going to warrant an above guideline rental increase. They must be substantial capital expenditures. Okay, so going back to the example of the roof situation that I gave to you, that's a substantial capital expenditure that must occur. And the cost of actually doing an above guideline rent increase is quite substantial when you're hiring somebody to do it for you. There are specific firms. We don't specifically do them here in our firm because they are so complex that there are actually paralegal firms and law firms that specialize in doing above guideline increases. Do we cover clauses in Michael's document last week? Yes, May, we did. So I believe actually, if you like, I will put in our email address into the chat box. And if you guys would like a copy of those clauses that we talked about last week, I'm sure somebody from client services would be happy to send you guys over a copy of that as well.
Yeah, if you can send it to me, Michael, that'd be great. And I can post it on our workplace group.
Yeah, absolutely.
That would be great. So yeah, lots of questions coming in here. So nice to see that. So from Chris, once our lease client's 1-year term has passed and the tenant wants to stay in the unit, I know it becomes month to month, but is there a form for the tenant or realtor to fill out?
No.
Okay, perfect. If the impact assessment comes in after the rent is increased, can we apply for above guideline then or at renewal?
So you have to apply at renewal. So it must be at the month to month stage, because the issue then becomes you've actually agreed to a certain term in that lease, whether it's 1 year, 2 years, 3 years, etc. Right? And what a lot of people don't realize is if you're signing a 3-year lease, you can't put increases in the 3-year lease. So you can't, form a standardized lease and say, well, we're going to increase by 5% in year 2, we're going to increase by 3% in year 3, so on and so forth, because they must actually be in line with the increases that are mandated by the government of Ontario.
Is it okay then to have a 3-year lease that increases according to the guidelines each year?
You can, however, for the purposes of ensuring conformity with regulations, I would suggest not doing so.
Okay, I have seen that clause in some schedules, so just curious about that.
Adding more occupants, allowing the landlord to increase. No, you just by adding occupants doesn't allow you to increase the lawful rent. So lawful rent is lawful rent, doesn't matter how many people live there. But what I will say is there have been instances where, for example, we had a client who rented out to a couple and the couple broke up and the gentleman continued to live in the home and he was a contractor and the gentleman reconstructed walls in the house because he couldn't afford the rent by himself and he turned it into a rooming house. Now he was collecting more than the lawful rent that was allowed. And my landlord client said, well, how can this happen? And I'm not making that extra money. So I want to increase the rent. I said, no, you can't increase the rent because the agreement has not yet expired and he hasn't gone month to month. But what we can do is we can look at getting these people who we don't know that are living in this house evicted. And we also need to look at getting the tenant who is living in there evicted as well, because the tenant cannot collect more than the lawful rent, because then he is in a position of becoming as sort of a subsidiary landlord and making more than what the lawful rent is, and that is in contravention of the act itself. So just keeping that in mind as well.
Awesome. Keep those questions coming, guys. I also have another question here about, we're talking about rental increases. What about new condos that have never been lived in?
Okay, so you've got so you've got a condo that's never been lived in. You can price it accordingly because listen, it's not subject to the standard price. So you have your tenants, they live there for a year, and then they move out. Sorry about that. And then they move out. So you're not subject to keeping it at the same price. You're not subject to, a minimum guideline increase. So let's say they were renting for 1,800, but now maybe their market rent is, 22. So you can actually market rent at 22. There's nothing wrong with that. However, if it was an old building that was subject to rent increase restrictions, you may wish to speak with us regarding how you could increase the rent, based on those restrictions, right?
Yeah. So just to clarify, then or just so I understand, if it's a brand new condo that's never been lived in before, and the first tenant is in there, the landlord after 1 year can increase their rent, and they don't have to follow the guidelines, right? They can increase it to whatever they want.
They have to follow the rent guideline, the 1.2%.
They do? Okay, even if it's a new condo.
Correct.
Okay. Raman, go ahead.
Hi, Michael. Hi,
Hi, Raman.
James. I have a question for the actually new buildings. As a tenant agent, can I put a clause that the landlord shouldn't go with should actually only can increase the rent by the guideline restriction, not as a new condo building? Can I put a clause, and does it work or no? If I want to help my client not to have a lot of increasement for the next year.
So I don't think it's probably necessary, because if they're going to follow the laws and regulations surrounding residential tenancy, they can't increase by above a certain amount anyways. So every year the government comes out and says, okay, this is the rental increase guideline and you have to follow this. And
for the new buildings, for the new condos after the December or November 2018, I think they can increase anything they want.
No, not if the tenancy is in existence. So if the tenancy
Toronto area.
Right. So if the tenancy is in existence, they have to follow the Residential Tenancies Act. Remember, the Residential Tenancies Act takes full responsibility of residential tenancies, right? So if the Landlord and Tenant Board comes out and says the residential tenancies increase for 2022 is 1.2%, the landlord cannot, doesn't matter what building they live in, cannot increase above 1.2% unless he or she applies for an above guideline increase and has to be able to substantiate.
So what was actually the Ontario or Toronto, I'm not sure, rules that after 2018 new condos or new buildings, they are not limited to the rent increase restrictions.
Right. So the rent increase restriction that you're talking about is if the unit becomes vacant, there's the older buildings that were prior 2018 that if the unit becomes vacant, you can't increase above the above guideline increase. But what we're saying now is if the unit becomes vacant and the market rent is now 2,200, but your tenant was paying 1,800 and they've left, you can go to 2,200.
Because I was thinking that for the new buildings that wasn't having occupancy before that date, they can increase every year. They can increase with the same tenant as much as they want.
No, not with the same tenant in the property. It must be a new tenant. So, for example, John is in the property and he's paying 1,800. right? John vacates the property and then Joe comes into the property. You can charge Joe $2,200. You don't have to worry about charging below market
Yeah.
rent. Does that make sense?
Yes, yes. Yeah.
Okay,
Thank you so
perfect.
much.
You're welcome. Alex, you have a question?
Hi. Okay. Yeah. Similar question. Because that's to my knowledge too, in newer buildings, they can charge whatever they want. So like I am currently in a new building. I pay $1,300 in rent and my lease is almost up. And he is telling me that when my lease is up, he's gonna charge me $1,450 because I'm the first tenant to live in this new building.
So again, I'm going to disagree because the lawful rent increase is 1.2. So we have to look at if you're paying 1,300, right?
Yeah.
1,300 times 0.012. This is $15.60. So you should be paying 1,315.6.
Okay, because you're saying a new tenant would have to come in, but he's saying that like after the year, he can do whatever he wants because it's a new build. So if it's a new, or if I'm the first tenant to live in the building, then they don't have any cap on their rental increase.
Yeah, so they wouldn't have a cap on the rental increase if you moved out.
Okay. But if I stay, then they can't do that. Okay, I didn't know that. Weird.
Yeah. Well, but they don't, they don't tell you everything, right, Alex?
He's a realtor too, though, so it's kind of funny, but yeah.
Okay. Should have invited him to today's boot camp.
Yeah, thank you.
Okay, thank you. Hamid, you have a question.
Yes, Michael, I got a quick question for you. For the rollover, when it goes into like month-to-month tenancy after the 1 year is complete, during that time, they can they can give the 60-day notice and take out the tenant that's there right now. And that tenant only subject to 1.2% increase, as you said. And the next person coming in is subject to the market cap, like wherever the market rent is at the time, that's what they can advertise it at.
Yes, if the building was built after 2018 or was built in 2018 or later. Now, you got to have a good reason to get your tenant out. Okay, and it's not just because you need to increase the rent. You got to have, next week, we're going to talk about terminating tenancies. So we're going to talk about things like, persistent late payment of rent. We're going to talk about rental arrears. We're going to talk about demolitions of buildings. We're going to talk about all of these things next week. Parents moving in, buyers, sellers. We're going to talk about all that stuff next week. So next week's going to be a little bit more in depth with respect to terminating tenancy, but you just can't terminate a tenancy based on the fact that you want a higher rent rate. Okay. And then is there a proportional between rooms and how many people can live in these rooms? So this goes, sorry, I'm just reading Neem's question here. So this goes back to your lease agreement. So in your lease agreement, it's going to specify how many people are allowed to occupy the property, things of that nature. You may also want to look at normal city bylaws and conforming with normal city bylaws, because if you have this problem whereby you're not actually able to have so many people living in the property, that may be something that you want to look at as well. Because remember, the landlord has to conform to local municipality or city bylaws.
I think that's all we have in the chat right now. Oh, no, sorry, Hamid had a question in here. When a new condo price is set, can we do a comparison in the area? But then if there aren't comparisons close by, can we conduct a comparison in a similar neighborhood in the city?
Well, respectfully, I mean, you're the real estate agent, so you're gonna know what the price is. If you don't have any sort of prices sort of available in your area, yeah, I definitely pick like the next closest neighborhood to sort of market compare to. I mean, of course, if you're looking at Markham Village, and maybe you're comparing rent to Rexdale, I probably wouldn't do that.
And actually, Hamid has his hand up. Go ahead, Hamid.
Yeah, it's a quick question for you, Michael. Well, it's great to know you in the real estate. I have another realtor once telling me when I contacted them, they said that the general rule of thumb in condominiums is 2 people per room. Is that an actual law, or is that something that he told me? He said he's had people move in, like 10 people move in, and all the utilities are included, so it puts pressure on the building itself.
Yeah, I would look at perhaps maybe condo management's going to have like a restricted occupancy, or the local city bylaw may have restricted occupancy. So you might want to look at that. I've never heard of like a rule of thumb, sort of speak. Listen, I just moved out of a condo, and the people that live next to me, there were 6 people living in a 2-bedroom condo. So, I mean, who knows, right? I have no idea. You know, so it all depends, right? So it all depends on local municipality bylaws. It depends on what does the condominium corporation have to say, because who knows, right? We don't know, right?
Okay, wonderful. Thank you so much.
Welcome. So in the case of Alex, as her building is new, after only must give the owner can give 60 days notice if she doesn't want to agree to the new rent. So no, you can't just terminate a tenancy based on the fact that your tenant doesn't agree to the new lawful rent charge. You have to have a valid reason to be able to get rid of the tenant. So the tenant has something called security of tenure, which means, you know, just because my lease has expired doesn't mean that you can get rid of me. You have to be able to get rid of me for a good reason. So those good and valid reasons would be, I'm selling the unit and the purchaser requires a unit for vacant possession, and you have to be able to substantiate that, or you are terminating the tenancy based on the fact that the tenant is persistently late with rent, or you're terminating the tenancy based on the fact that the tenant owes substantial rent arrears. And those substantial rent arrears are, you know, the rule of thumb is usually, you know, over $1,000 or something like that. You know, the landlord and tenant board isn't look at rent arrears that are sort of, you know, less than $1,000, because you should be working on a payment plan. If you can't work out a payment plan, you know, for something that's reasonable, and we'll talk about, again, terminating tenancies next week, you know, then it becomes an issue. Okay, so we can't just terminate based on the fact that she doesn't agree to the rent increase notice. What she could do in the case of Alex is she could pay her $1,315.60 to her landlord and dispute the rest and say, you know, you're applying above guideline. I'm going to be filing an application with the board. Okay. And Alex could also request that her rent be paid into the board until such time that the board has determined what the lawful rent should be. Okay.
Sorry, and just to clarify, is it 60 days notice to increase rent or 90?
It's 90 days notice.
Okay. Awesome. All right. Let's see what else we've got coming in. All right. Let us know if you have any more questions. Yeah, it's rent increases always generate a lot of questions. And yeah, if you have a situation, feel free to raise your hand and we can unmute you. Let me see what else is coming in here. Okay, I think we've addressed everything so far. So
I think so.
Michael, one more quick question for you.
Yeah, sure.
If the landlord decides to increase the rent and gives the notice, and the tenant says, no, I don't want to increase rent, do they have like the right to kick them out even in winter months?
So what's going to happen is if he continues to pay the old rent rate and not the new rent rate, provided the new rent rate is lawful, then we need to start the process of an N4, which is, you know, the process for eviction. Everybody has this misconception that when winter hits, you can't be evicted. Okay, that's not true. The issue becomes vital services cannot be shut off in the winter. So things like hydro, heat, water. Okay. Just because you don't pay your rent doesn't mean that you're protected in the winter months. Respectfully, you know, vehicles still operate in the winter. So moving trucks still operate. And, if you know, the old adage is, if you don't pay, you don't stay. So, we go back to then starting the process of rental arrears.
Okay, thank you.
Okay, you're welcome.
Michael, may I ask a question? This is Gillian.
Absolutely.
So you have a new landlord, and they take over the lease. So do they at that point take over the lease, or they have to sign a new lease? So if I'm a new owner,
Yes.
will I
So
be taking over
what
the lease
happens?
because I'm inheriting the tenant?
You're inheriting the tenant, so it follows per stirpes. So basically what that means is anybody that buys that property is inheriting the tenant, unless they're buying the property for their own personal use. And when we talk about buying property for personal use, that means we can't re-rent it within a 1-year period.
So if I buy it on January 1st, I cannot re-rent it for another year because I inherit a tenant, and that becomes like a start of a lease. Is that what you're saying?
So, no. So what I'm saying is, if you buy a property and it has a tenant in it, right? You can't evict the tenant unless you, as the purchaser, require the property for your own use.
Okay, so then the lease that was there before, is that something then get transferred to me?
Correct.
And then I have to find out when was the last rent increase before I can increase the rent.
Correct.
Okay, great. Thank you. That's all I want.
You're welcome.
And great question.
Mahima.
So what paperwork is required in that case so that it's reflected that the new purchaser is the new landlord?
So that would be done between the solicitors upon closing. There would be some now again, I don't practice real estate law, but I'm sure the real estate lawyers would have some sort of documentation that would state that there's an assignment of the agreement to the purchaser.
Okay.
And the tenant wouldn't be required to sign anything because the seller and the purchaser, the seller has the right to dispose of his assets as he so chooses.
Right. Okay, perfect. And then in the chat, we have a question. So what if the landlord puts a clause in the rental? I'm assuming this means agreement. What if the landlord puts a clause in the rental agreement and the tenant signs it, but the clause is in contravention with the residential tenancy agreement? Is the rental agreement still valid?
The rental agreement may not be valid. Again, depends. Do you have a severability clause? Do you have governing clauses, things of that nature? Again, these are all things that I wanted to get to last week, but unfortunately we didn't get to. So severability is, for example, I may have a clause in my agreement that's annexed to my standard form of lease where the clause says, notwithstanding anything in this agreement, should any portion of this agreement be deemed null and void by the Residential Tenancies Act or by a governing body governing such act, that the rest of the clauses in this agreement hereby stand in full force and effect, right? And you want to make sure that you include severability, because if you don't include severability, and then this goes back to he who wrote the contract is responsible for it. So that contract may become null and void, and the Residential Tenancies Act will then kick in, and the landlord and tenant board will say, well, if this isn't valid and you have no severability clause, then perhaps maybe the entire lease is not valid.
Okay.
And then Wally asked, my tenant is on a month-to-month and I'm planning to sell my property. What are my options? So option number 1, list the property for sale. Hope you get a buyer. And then we follow the line whereby if the purchaser requires the property for vacant possession for his own personal use, you must fill out an N12 and a statutory declaration or an affidavit, and you must be able to provide those documents with respect to that and attach all of that as an exhibit to your N12, and make sure that you follow the laws regarding the N12. Remember, we still have to pay our tenants 1 month compensation to leave. Now, tomorrow or next Thursday, we can talk about things such as cash for keys, where we can do side deals to get tenants out and things of that nature, because those often work quite fruitfully in our favor for our landlord clients, even though, you know, it could be quite a sum of money that we're paying, but you know, it would be better than having to go to the board and waiting for a decision of the board. I just want to say that we did a couple of cases approximately 60 to 90 days ago, and we're just getting orders now. So I just want everybody to be well aware that, you know, 60, 90 days ago, I did cases and I'm just getting orders today. Like, that's how far behind the board is. So that's why if we can utilize the tools that we have in our own toolbox to avoid having to go to the board, it's always the better route to go. But for sure, Wally, we'll talk about that next Thursday.
Awesome. Thanks for that. Hamid, go ahead with your question.
Hey, Mike, sorry to bombard you with so many questions.
That's okay.
Another quick question for you. Now, the 1.2% increase for rent per year, is that also the same as for a commercial, or is it different?
No, so the Commercial Tenancies Act is completely different from Residential Tenancies Act. Commercial, there is no rental guideline increase.
Yeah, that's right. Because I have a tenant right now, and they're disputing 5% per year. So I told them there's no actual guidelines, the actual paperwork.
No, there's not. And you know, we have to keep things in mind, like, you know, increases in TMI, you know, the cost per square footage, all of those things that come in to sort of the commercial guidelines, right? So when we're looking at doing commercial tenancies, you know, if you've got, you know, John who's renting a commercial space, you know, we try to project what those costs are going to be for the next 5 years, things of that nature. If you're putting them into a 5-year lease, right? You know, maybe how we increase TMI and how we increase square footage costs and things of that nature, right?
Perfect. Thank you.
You're welcome. Can we get this severability clause somewhere? Ellen asks. Absolutely. I will send it to Jane.
Perfect. Thank you. And I'll put it on the workplace group for you guys, along with the clauses that we discussed last week. So that's great. Let's chat a little bit about, again, above guideline rent increases, but when they're done in bad faith, what can a tenant do, or what does a tenant need to do in order to prove that? What kind of
Yeah. So the tenant has to be able to provide evidence to the fact that the above guideline increase was done in bad faith. So these are things like, you know, perhaps maybe the landlord sent some sort of letter to the tenant to let them know that, you know, if you don't comply with me on this, I'm going to do X. Right. So it's almost like a reprisal, right? So you can show that it's been done in bad faith. It's the same with, you know, the N12s that are often done in bad faith too, right? So you have to be able to, as a tenant, be able to substantiate the bad faith, right? Well, maybe I've had a problem with my landlord for the last 6 months and he's been doing nothing but harassing me, and all of a sudden he applies for an above guideline increase, but he hasn't done any capital expenditures, right? And this is why I am so gung-ho about doing move-in pictures. What is the state of the property on move-in? You know, all of those things to sort of CYA for your tenant, because, you know, if something like this happens down the road, we can say, well, you know, when I moved in, there was already a new furnace. So applying for above guideline increase for a new furnace when you just bought one, you know, isn't going to work. You should have charged me, you know, appropriately when I first moved in, you know, those sorts of things, right? Being able to demonstrate the bad faith.
Yeah, that's good to know. So question in the chat, if the landlord has just effected the 2021 60 days ago after the 90-day increase, is there a waiting period before the 2022 increase can be applied?
If the landlord has just effected the 2021 60 days. Well, the 60 days ago. Well, 2021 was 0%. So he
Was it
shouldn't,
30%? There was a figure for 2021. And then, the 90 days notice was given, and then the
Yeah.
increment did fall into effect.
it has to be a full year. You can't,
Okay, so the waiting
Yeah.
period is full year.
yeah. And
Okay.
it should be at the, so if your tenant, so for example, if your tenant moved in May, right, you should, the rental increase would come into effect in May the following year. Right? So you should be increasing for May 1st every year.
Yeah, no, this is an existing tenant who did
Yeah.
not get any increment. 2019, there was 0. Then
Yeah.
2021, there was a figure. So that was
Okay.
applied. So
Okay,
that's
so he's got to wait for the 2022 increase until for an entire year. He can't just on January 1st
Okay.
reinstate 2022. It doesn't work that way. He's got to wait an entire year. Okay, because it's based on when the lease was entered into and agreed to. Does that make sense?
Fine. Yeah, basically it's from the last increase. The next increase should be 12 months apart. from what I
Correct.
understand. Yeah.
Correct.
Okay.
Okay.
Good. Thanks.
You're welcome. client-
All right, so in the situation where tenants have left their belongings, how do you handle that situation?
Oh, this is always fun. So tenants have 72 hours to come back and collect their belongings. If they don't, you can either dispose of the belongings or you can put them in a storage unit and charge them for them, or upon disposition of the assets, you may wish to do it yourself. You can either, put them in the garbage, or if they're of any value and perhaps maybe your tenant owes you in back rent, you may want to sell them. But they only have 72 hours to come back. Okay, and that 72-hour window is not because you're letting them back in to move anything back in. You want to make sure that when you're there, you've already changed your locks in the 72-hour period. You've already got your keys. All of those things have already happened, and that you're just letting them back in so that they can remove their items appropriately. Okay. And then Chris asked, my client wants to sell his condo, but his tenant to remain. What paperwork forms need to be filled out, if any? Chris, you don't have to do anything. Leave that up to the lawyers. That's all up to the lawyers. Okay. I would disclose on your documents that it's tenanted, buyer to assume tenant, unless buyer requires vacant possession for personal use.
Yeah,
You're
so
welcome.
just to add to that answer, yeah, if you have a listing, I would just put that in the realtor remarks, just saying that tenants want to stay, wording to that effect, so that when offers come in, they know that. Hamid again, I'm not sure if this was asked, but if the landlord has a 3-year lease term, is it still subject to 1.2% per year?
No. So what you've agreed to is you've agreed to that rental rate for 3 years. So you're not going to be able to increase until the 3 years is up. Sorry, that's how it works. Because your tenant has to be out of the lease period. So if it was a 3-year term, 3 years and 1 day, then you can increase the rent. Okay, and this goes back to adding in unlawful clauses such as, I'm increasing, your rental rate by 5% every year in your 3-year contract. You can't do that either. Okay, so when they're stuck in a lease term that's 3 years long, it's 3 years 1 day you can increase. Okay. Just trying to see.
Yeah, just to recap, so 1.2% is the rate for 2022.
22, correct. And I know, guys, it's horrible. 1.2% is peanuts. I know, it's bad, but we've sort of been kicked, hard economically. We're just starting to rebound, and I'm going to speak freely about this, not just as a legal representative, but I also own a finance company as well that, we do a lot of stuff in residential real estate. And, we can see the number of bankruptcies coming in every week. So we know how hard our economy has been hit compared to pre-COVID versus today. The number of bankruptcies that come across my desk on a daily basis has multiplied by at least 6. It's very intense. So I think that's why the government is saying, we recognize it's below inflation, because inflation is 5.25 in the past year, but 1.2, understanding that, we know that there's a problem in the economical market. And I think that's why they chose that number, was to ensure that the affordability of housing also exists for people as well. If the tenant is on month-to-month, how can he switch to 1 or 2 year contracts and stay in the same premises? They can't. So in accordance with the Residential Tenancies Act, and we talked about this last week, was that if you're redoing leases and rewriting leases, any new lease that you write, or if it's a renewal agreement, is in contravention of the act, because the tenant has the right to security of tenure, which allows them to go month to month. And it's at the option of the tenant whether or not they wish to stay. So the landlord should not be forcing the hand of the tenant to be signing a new contract. And what we discussed last week was that, we found that those contracts to be null and void. And, and especially if they had large rental rate increases in new contracts, then the landlord then has to reimburse for the money that he or she took during the course of those changes in material contract. Also, does the tribunal cost to you as a tenant if you're demanding something from it? Yes, but it's like a fraction of the cost. So tenants pay a fraction of the cost of what landlords pay. And there's also something called a waiver. And this also helps the tenant as well. So say for example, the tenant is on disability and he or she is only making so much income, and for them to pay the filing fees would be excessive. So we file a waiver to get the filing fees removed, so then we don't have to pay for them. Okay.
Yeah, that's good to know. Okay, perfect. We have a few more minutes left here. If you have final questions, get them in now. Yeah, otherwise, thank you always, Michael, for joining me. This has been super informative.
Absolutely. Ellen's asking me one last question, and I can see her sitting over there too. Hi. I leased the house with pet restriction. In a couple of months, my tenant bought a dog. And I asked the tenant to leave based on breaking the agreement. You may not. So section 14 of the Residential Tenancies Act, pet restriction clauses are null and void under the Residential Tenancies Act. I'm sorry, Ellen, but there's nothing you can do. Now, if your tenant happens to go and get 4 dogs and 6 cats and some chickens and is running a zoo, call me. We'll talk about that then. Okay.
Awesome. Perfect. Well, I think that does it with the questions. Oh, Hamid, with the follow up to that one, what if the animal is doing damage to the property?
N5, my beautiful friend, N5. So we will talk about N5s next week as well, but N5 is damage to property caused by tenant that wouldn't be subject to standard maintenance or repairs, which is the responsibility of the landlord. So if my dog, which Esther never would, chew a baseboard because she knows better, but let's say she did, I would become responsible for the fact that my dog ate an entire baseboard. Okay, so within reasonable maintenance and repairs, and replacing baseboards because your dog ate a baseboard is not a reasonable maintenance or repair. Okay, so N5, which then the tenant has to pay for the damages, failing which if they don't pay for the damages, then it's sayonara, see you later, we're going to the board, and if you don't pay me by the time we hit the board, then we're just going to get an order and, off you go, right?
Perfect.
What if the animal, what if the animal is harming other tenants? Yeah, so again, that's going to be an N5 for unlawful interference with other tenants' tenancies. Okay.
Yeah, so we'll be
Um,
talking about ending tenancies next week. Yeah, thank you. Thank you, Michael,
Thank
for
you
your
so
time
much.
today. And thank you, everybody, for participating. That makes it a lot easier. And yeah, we'll see you on the next webinar. See you next week, Michael.
See you next
Thank you
week.
very much.
You're welcome.
Thanks,
Take care, guys.